So with any further ado then, let's start then with this first session, which will deal then with SPLUMA and NBR requirements for plan submissions. And that comes then from a list that was submitted to SACAP by some of our local authorities, and also my personal experience being a member of the LSD committee when we looked at plans submitted to the committee, where the shortfalls then were. Okay, so just to look at what we are going then to do this morning and early afternoon, first of all, we're going to look at where is the mandate? Where does the mandate come from for local authorities then to request plans to be submitted to them, so that they can either approve or refuse them? Secondly, we're going to look at one or two aspects captured in some of the SACAP board notices, where we as professionals are then required to comply with certain requirements. Then I'm going to talk a little bit about SPLUMA, which is the Spatial Land Use Management Act, that have replaced quite a lot of previous acts regarding land use development, building line relaxations, etc. For instance, now falls under that. Then we're going to look at the National Building Regulations and Building Standards Act and a few requirements in that, so that we can have a better understanding of why local authorities are asking us to comply with certain things. And then obviously the National Building Regulations itself. There are a few regulations, especially in Part A of the National Building Regulations, specifically then requesting certain things to be on a building plan for us then to submit and to get it approved then at the local authority. And then I'm going to end off with a few things out of SANS 10-400 Part A, especially I think it's Form F1. That's a voluntary form, but that will assist us in actually making sure that when we submit building plans to a local authority, that we indeed comply then or have captured everything on our building plans like what we need to do. Now, before I carry on, I just want to, and I can actually ask the question, what is the purpose of a building plan? You can write it down if you want to, but my view on what is the purpose of a building plan is basically your communication to the local authority as well as to the contractor on, first of all, to the local authority on how you did satisfy the minimum requirements of the National Building Regulations, as well as some other requirements from other legislation like SPLUMA. And then secondly, it's the recipe, with other words, the blueprint that the contractor have then to use to construct the building as designed then by us, the architectural professionals. It is a legal document. Once it's been approved, it becomes a legal document. And quite interestingly, if you go and read through some of the Constitutional Court case judgments, especially those made by Constitutional Court JAFTA, you will see that non-compliance with any aspect of the National Building Regulations and Standards Act and the associated National Building Regulations published then in terms of that act constitute a criminal offense. And we will touch on that also a little bit later. So what I'm going to, or my main purpose then here today, is to highlight those things that we don't do perfectly and where local authorities are then complaining that we don't do so. But I want also to bring to everybody's attention the importance and the reason why then we have to comply with that. So first, let's look at the mandate. Where do local authorities then get the mandate to actually approve or to refuse our building plans that we submit to them as professionals? Now, indeed, we are professionals. And since the 1st of July 2006, only registered professionals can submit building plans to a local authority. So we are professionals. And when we submit a building plan to a local authority, it is supposed to be a professional submission. Next week, we will talk about the forms, and especially Form 1, where we make a declaration on how we are actually satisfying all those requirements. And my personal opinion is that if we as professionals do comply 100% or nearly 100% with all the requirements of the National Building Regulations and Standards Act and the regulations itself, then and that is for me also the reason why Form 1 is then included via the regulations in Sandstein 400 Part A. We as professionals do not have to have our work checked by somebody else. But unfortunately, it's now nearly 20 years later. We still sit with a situation where we are acting as professionals, but the work that we do, unfortunately, does not always show that we are professional indeed. We try to do shortcuts, we try to please clients, and in so we fail then to comply with absolute minimum requirements that a local authority then need to make sure that we comply with so that our building plans can be approved. So first, let's look at, I just want to see if I can get that away here. Is there a way that I can get that black spot away there? Sorry, normally I'm working on 2 screens and I've only got 1 screen here today. So anything that I bring up is giving a black spot so that I see everybody actually now see. I try just to move it, can't even move it out of the way. Okay. I'm just going to move it till they fix it so that we can actually see what's going on. So first, let's look at the Constitution of the Republic of South Africa in 1996. Now, the Constitution of the Republic, as you can see there, is the supreme law of the country. That is the law of all laws, and mandates are provided in there for the legislator, etc., then to make laws, etc., and how these laws then should be made. So it provides the legal foundation for the existence of the Republic. It sets out the rights and the duties of its citizens, as well as it also defines then the structure of government. Now, since 1996, I don't know if you're all aware of that, our Constitution has already been amended by 17 Amendment Acts. And today we formally refer to the Constitution then as the Constitution of the Republic of South Africa. It was previously numbered as an Act 108 of 1996, but since the passage then of the Citation of Constitutional Law Act, we actually do not number or allocate Act numbers to the Constitution or any of its amendment acts anymore. Next, we look at the rights. Now, this comes from Chapter 2 of the Constitution, the Bill of Rights. And the Bill of Rights is a cornerstone of the democracy in South Africa. It enshrines the rights of all people in our country, and it affirms then the democratic values of human dignity, equality, and freedom. And the state has got the legal duty then to respect, to protect, to promote, and to fulfill these rights in the Bill of Rights. However, some of these rights can be subject to limitations, but, and I think that is something that we sometimes forget, from acts down to our own estate rules or our own rules that we might have in our house, all these rules or all these rights, or the limit that we place then on rights that are given to us in the Constitution, must actually satisfy then Section 36 of the Constitution. I'm not going to go in there, but there's quite a lot of things there that we then have to take into account. And that is why in many cases you will see that things go through a process where it needs to be, where everybody needs to check that whatever they want to do, for instance, comply with the Competitions Act and the Equality Act and a few other acts that is being put in place as per the Constitution then to protect the rights of the citizens of this country. Now, to who does the Bill of Rights apply? It applies to everyone, to all law, and it binds the legislator. With other words, it binds Parliament who makes the laws. So Parliament cannot go and make a law that falls outside the scope or the rights that has been given to us in the Constitution. It binds the executive. With other words, it binds the president and his cabinet. It binds the judiciary. It binds, for instance, all the courts, as well as all organs of state, from local authorities up to state departments. All of them have to comply then with the Bill of Rights and have to respect and apply the Bill of Rights. It binds natural, with other words, you and me as a natural person, with blood through our veins, and it also binds juristic persons, with other words, companies, trusts, estates, etc., to the extent that it is applicable, taking into account the nature then of that right and the nature of the duty imposed by that right on that person or entity. Then Section 24 of the Bill of Rights deals with the environment. We are designers of the built environment. The built environment is part of the environment. And we've got a very special job then in terms of our Constitution, because we have to ensure that the rights of people regarding the environment are actually not being done away, etc. Because all of us has got the right to an environment that is not harmful to our health or well-being. So when we design a building, we must make sure that the occupant or the user is safe in there. It doesn't help that we can design buildings and we use structural members that are not strong enough and the building come down upon us. We've got a right to make sure that that building is not harmful to our health and well-being. And for that matter, we've got the National Building Regulations, because the main purpose of the building regulations, I'm not talking here about the act, but the regulations then, is to ensure that the environment, the built environment, is then a health and safe environment. It also goes further to have the environment protected for the benefit of present as well as future generations through reasonable legislative and other measures that prevent pollution and ecological degradation, that promote conservation, and that secure ecologically sustainable development and use of natural resources while promoting justifiable economic and social development. That is why in 2011, we had an amendment done to our National Building Regulations to include Section X, which deals then with sustainability. And then the first chapter there, XA, was then promulgated in the same year, which we all know, energy efficiency. Being a member of the TC, the Technical Committee at SAPS, we have already put or done a standard for water efficiency, and through the task team that I'm also involved on the DTIC, we are trying now to get that Regulation XB then as part of the National Building Regulations, so that we can also then look at water efficiency in the future in our buildings. Then just administrative action. And I think here is where we as professionals have to know our rights, that we have to know the constitutional rights that every citizen in this country have. Now remember, the submission of a building plan to a local authority, the approval or the refusal of such a building plan is an administrative action. And the Constitution, as you can see, they say that we've got the right to an administrative action that is lawful, that's reasonable, and that is procedurally fair. And if our rights have been adversely affected by any administrative action, we have got the right to be given written reasons. So if my plan is getting refused by a local authority and I ask for them to give me in writing the reasons why it's been refused, that's an administrative action and that is protected in terms of the Constitution. I think as professionals, we have for a long period of time just adhere to the will and whims of certain officials at local authorities. And some of us basically just vice versa. We have hoped that the local authorities will just agree with our whims and whims. But yes, here you can see it is an administrative action and that when we ask for written reasons, we should get it. And therefore, the Constitution also say that national legislation must be enacted to give effects to these rights. And that then needs to provide then for the review of an administrative action by a court, or where appropriate then an independent and impartial tribunal. And it imposes actually a duty then on the state. And remember, when we talk about the state, it includes local authority to give effects then to the rights in subsections 1 and 2. That is, now everyone has got a right, and those rights has got adversely affected have been the right to give given written reasons for that. And the state has got a duty to promote then also an efficient administration. Now we know that that's not always happening. There are problems, but rather fighting that, I think where we start assisting, then it becomes much more effective and we actually get much quicker our problems resolved. Now, going back into what I start off, and that's why I just gave you a little bit of a background regarding the Constitution. Now, Section 156 of the Constitution deals with the powers and the functions of local authorities or municipalities, as they call it here. And it says here that the municipality has got then a constitutional power and function as an executive authority. With others, they've got executive authority in respect of, and they've got the right then to administer the local government matters as listed in Part B of Schedule 4 and Part B of Schedule 5, and any other matter assigned to them by national or provincial legislation. Now, if you go to the back of the Constitution and you look at Schedule 4, Part B, and that's the only time that it's actually been mentioned there, local authorities has got the right then, and they've got the executive authority to do so, to administer the building regulations as per the National Building Regulations and Standards Act and the associated national building regulations, and then also municipal planning. And today we've got the Spatial Land Use Management Act, or SPLUMA then, that regulates that. The Constitution further says that the municipality may make and administer bylaws for the effective administration of the matters which it has the right to administer. But please don't stop reading there. Read it in context. Subject then to Section 151, subsection 4 of the Constitution. A bylaw that conflicts with national or provincial legislation is invalid. And we will see that the National Building Regulations and Standards Act require specific things that a local authority must adhere to before a bylaw, which then let's call it, interfere then with the functions of the national building regulations will be valid. And one of that reasons is, one of that requirements is that the Minister of Trade, Industry and Competition must then approve of it, or some person or some entity delegated then by him to do so. If there is a conflict between a bylaw and national or provincial legislation, because the national and provincial legislation is inoperative, and in this case we can't say so because the national building regulations is operative, the bylaw must then be regarded as valid for as long as that legislation is inoperative. Now, in our case, the national building regulations are not inoperative, so that part of the national building of the constitution then is then not acceptable or not applicable then to the national building regulations. So now we've seen where we've got the mandate from, or the local authorities has got then the mandate from. And what is their mandate? Their mandate is basically then to administer the national building regulations as on behalf of the minister, and also where it comes to SPLUMA, Spatial Land Use Management, they've got much more executive powers, and they also have got the right then to administer that on behalf then of government. Okay, so we've gone through now the constitutional requirements, where the mandate is being given to the local authorities then to administer the, for instance, the national building regulations. Next, we go and look at SACAP. Now, we all know that SACAP is the regulatory body put in place by the Architectural Profession Act, Act 44 of 2000, and that act provides them then with certain powers. Basically then to ensure that what we do is sound, and in doing so that the public is then protected. And therefore we've got the Code of Conduct. And the Code of Conduct specifically and explicitly states that in the performance of our duties, we shall comply with the National Building Regulations and Standards Act 103 of 1977. Town planning schemes, National Heritage Resources Act, and any other built environment laws and other applicable law governing the works. Now, I just want to say something here, and I've got it quite a number of times. Local authority in approving building plans has got a certain mandate. Their mandate is to apply the National Building Regulations and some other applicable acts, like town planning schemes, which falls under SPLUMA. They must ensure that, for instance, the National Heritage Resources Act is being applied, and that there are other sensitive requirements about sensitive areas where there might be prohibition in terms of national acts then to actually to do developments. That is their duty. But when they actually look at our building plans for approval or refusal, what we as professionals have to do is only provide them with the minimum requirements that are in these, specifically then in the National Building Regulations. However, we have to be aware of the fact that there, and somebody told me at one time, there are about 144 acts that are mentioning buildings and the requirements for buildings. Local authorities check only one where it comes to the building plan submission. I'm not talking about now town planning, etc. Building plan, the building itself, they only have to check if we comply with the minimum requirements as set in the National Building Regulations. But as professionals, we have to ensure that our client, because we are the agent of the client, complies then with all the other legal requirements. So you might design a restaurant, for instance. You might comply with all aspects in terms of the National Building Regulations. But the client may have to obtain a license from a local authority or from any other authority. And in terms of other legislation, those authorities, before granting such a license, will look at other aspects apart just from the National Building Regulations and Standards Act and its National Building Regulations. And some of those requirements might be a little bit stricter than the National Building Regulations. And I think here is where a lot of conflict actually happens then. Building control I haven't got the mandate to check that, but we have to make sure that our clients comply with all these additional requirements, because they maybe have to submit it later on then to other entities, etc., for approval. For instance, if you design a small clinic or a hospital, there are certain requirements. You can get your building plan passed by the local authority, but then when you go to the Department of Health, national or provincial, you might find that you do not comply with certain aspects that needed to be incorporated right from the start in that building. And again, the mere fact that the building plan was approved then by the local authority does not mean that it satisfies then all aspects of legislation. And I think that is something that we just have to make sure that we comply with. And we've got a duty then in terms of the code of conduct to comply then with other built environment laws, apart from just complying with the town planning scheme, the building regulations, and maybe one or two others. In the publication guideline for professional fees, I just want to highlight here stage 1, the inception stage. And that's a stage that in my dealings with professionals, I found that we sometimes overlook a lot of these things, and we only discover constraints, etc., later on during the design process. And then it becomes very difficult to explain to the client why we now need to do this and not that, etc., especially after the client has already accepted the concept and the budget. And now all of a sudden, because we actually did not comply with the requirements of stage 1, we found out later on that there might be other things that we have to comply with. So I'm just going to highlight there point B, which is we have to determine the site and the rights and the constraints. Get a copy of the title deed. Look at the title deed, and we will go into that a little bit later. Check if there's any constraints in that title deed regarding the development that your client wants to do. Look at the Surveyor General diagrams. Are there any servitudes registered on that property? Go to the local authority. Go and check the town planning scheme, because the land use or that property might not be zoned for that particular land use that the client wants to use his building for. Remember, the National Building Regulations doesn't check the rights of use of the property of the building on the property. That is a town planning issue. So, but we have to get all these right before we can actually submit to the building control to check if our building then complies. Okay, so I've put the whole stage 1 on there, but it's just those 2 points that I just want then to highlight. Oh, apart from number G, other statutory authority applications. Does the building fall under the jurisdiction now of the Heritage Act? Do we have to get permission from the Heritage Authority in our province then to comply? Or for us, or are there any other restrictions imposed on that? Are there restrictions placed on certain things in terms of a guideline of an estate, or there might even be restrictions placed in a town planning scheme on what we cannot do? Let's look at building lines. Are we going to keep within the building lines? Do we know the time constraints that are imposed in terms of regulations, the SPLUMA regulations by local authorities, where it comes to building line relaxations, where it comes to rezoning applications? Because those are the things that are most likely misunderstood, and we give a time frame to our clients when we get the brief from the client, and then we found out that our time frame cannot be achieved, or we cannot complete the project within the time frame that the client that we have said to the client that we will do so, because we did not take those other requirements into place. Now, when I was a student, I worked for a local authority during holiday periods, and yeah, and I think that gave me quite a lot of insight, especially because of the fact that I worked for a planning department of a local authority. That was still under, before SPLUMA was there, so it was still under the old laws and stuff like that. But it gave me a lot of insight in what must actually happen, and why it takes so long before a certain thing can happen. There might be a requirement to get public participation, and therefore a notice must be published in a newspaper or even the government gazette. A minimum time period have to elapse for comments to be received. Then there might be a minimum period for comments to be addressed and or readdressed, or for new publications to go out, etc. So all these things add up. So in many cases, it is not specifically when it comes to land use management requirements, and why it takes so long. It is not because an authority just wants to take so long. They have to comply with legal requirements where it comes to specifically public participation, and those periods are then either set in law or in bylaws, etc. And we need to make sure that we know that before we go to our client and say that we can do a thing within a certain time period. So that's why I brought those two things up, so that we just have to understand that, yes, we've got a duty, a legal duty imposed on us by our code of conduct to comply then with the building regulations, SPLUMA, and other legislation, although it might not be checked by local authorities for plan approval purposes. And also that we need to know the time constraints specifically, and how long certain procedures will take for special consents, building line relaxations, zoning applications, etc. Because remember, we cannot actually submit a building plan to building control before all these things are done and dusted, because they will not even look at that, because the right then to erect a building that we have submitted to them is not in place as yet, and we must make sure that the rights are there first before we can actually then submit a building plan. Okay, I've talked a lot about SPLUMA. It's quite new, and in many cases, I think it's a swear word amongst professionals. Spatial Land Use Management Act, and that act came into play for a specific reason. It still has got its problems, and that's been sorted out currently in court cases, etc. But at least we know, if we know what is required in terms of SPLUMA, we can also then enlighten our clients, and that will also make sure that we do not then make errors when we submit building plans to local authorities and do not get our plans approved. So those of you who practiced before SPLUMA, there were quite a few things in place. You had the Town Planning and Townships Ordinance. I just want to minimize that on my side. Of Ordinance 15 of 1986. I think let me just give you a minute or two just to answer that question quickly so that you're not distracted. Okay, so let's look before SPLUMA. Before SPLUMA, and in many cases, it's still applicable. depending on when applications were lodged, etc. We had the Town Planning and Townships Ordinance of 15 of 1986, and there were even previous ones prior to that. I think it was only the metros that could handle town planning issues directly. If it was a smaller town, it went to the Townships Board of the province to make certain decisions. We also had the Less Formal Township Establishment Act 113 of 1991. We had the Development Facilitation Act 67 of 1995, or the DFA, which I can't remember the other province now, but there were only two provinces that actually made quite extensive use of that. That was KZN and another province. There's the Removal of Restrictions Act 84 of 1967, where you had to go maybe via legal representation to the so-called administrator of the province to have restrictions removed from title deeds. You had the Physical Planning Act of 88 of 1967, and you had the Physical Planning Act 125 of 1991. So all those things, you can see it's a myriad of plans, and some of them, to be honest, require the opposite of what the other one did, and it was quite an issue sometimes to get town planning issues resolved before you, like rezoning and stuff like that. And it took quite some time sometimes because you had to get permission, not just in terms of one piece of legislation, but maybe a couple. Then we've got SPLUMA. Now, SPLUMA is national framework legislation, and it came into operation on the 1st of July 2015. So now here for the first time, we've got a national framework legislation. So we haven't got the bits and pieces all over the place that we have to comply with. We've got one set of legislation, and from that legislation, then we work downwards. Basically, the same principle that the National Building Regulations and Standards Act was established under in 1977. So the primary aim of SPLUMA then is to provide national, provincial, and municipal spheres of government with a framework relating to the establishment of policies and systems relating then to land use management. I try always to explain the difference between SPLUMA and the National Building Regulations as follows. SPLUMA look at how the building, how the development will fit into the immediate environment, as well as the global environment, or the national or provincial as well as national environment. Where the National Building Regulations look at the building itself. How is that building going to be fit for occupation? How is that building from construction, with other words, from cradle, actually to cradle as we call it these days, going to be sustainable? So two different aspects being dealt with two pieces of legislation. But when we submit a building plan to a local authority, we must make sure that we comply then with both of them. So what is SPLUMA? I've already said it's the abbreviation for the Spatial Planning and Land Use Management Act. That is Act number 16 of 2013. It was passed in 2013 by Parliament and is national law. It falls under the jurisdiction of the Department of Rural Development and Land Reform, or the DRDLR, and that law then gives them the power to pass regulations in terms of SPLUMA, as well as to provide additional detail then on how the law should be implemented. That is now the regulations that the department can actually put out there. SPLUMA and the local authorities. So what are the requirements imposed on local authorities by SPLUMA? Now, the biggest one was that local authorities had to approve and to adopt a single land use management scheme within 5 years from the enactment date. So it was enacted in 2015, so 2020, they had to comply with that, a single land use management system. Because of the way that local authorities were set up pre-1994 and through the local Authority Demarcation Act that came into play, that put a lot of other areas under jurisdiction of local authority. And in many cases, different towns were now part of one municipality. We had different land planning schemes. And in many cases, it was very difficult then to actually get to what one and what scheme should now be applicable to this piece of land. So each local authority now have to have a single land use management scheme. They must also consider appropriate categories of land use management, compliance with environmental legislation, as well as provisions to promote the inclusion of affordable housing. And they've got a duty then to pass bylaws to formulate the procedures to give effect to and to enforce then the provisions of SPLUMA. They must establish a municipal planning tribunal. I think I've already alluded to the fact that it was only your metros in the past that had its own planning tribunal. If you're in a smaller town, the planning tribunal was set up by the province to decide on those matters. And that is then to determine land use and development application within its jurisdiction. And that goes back then to section or to Schedule 4, Part B, which give then the executive powers and the administrative rights when it comes to municipal planning then to local authorities. Now we all ask, how will it affect our plan submissions? It provides then requirements for rezoning applications. And as I've said earlier, if you have to do a rezoning application, go and find out first how long will it take, because there might be legal requirements that you can't shorten the time period for that. So, and that is basically due to the public participation procedure that must be followed. There are rules for township establishment. Township establishment means that where you take virgin land, like agricultural land, and redevelop it as a residential area or a business area. So those requirements must be put in. With other words, the reuse of gray areas, brown areas, green areas, etc. The requirements for the subdivision of land, as well as for the consolidation of land. All of this now brought back to the jurisdiction actually of the local authority to say yay or no, and to impose certain restrictions on that, because they deal then specifically with that area. I've mentioned previously, if there was a restriction on a title deed, you had to apply to the administrator of the province in the old area, then to have that restrictive conditions removed. Now it falls under, or it's part of the duty then of the local authority. And then also the establishment of the sectional title scheme or sectional title schemes, not the establishment of that, but basically the approval of that and the restrictions imposed on that, etc. How does it affect the owners of properties? And these are things that we have to know, because in our brief, when our client and our client provides us with the brief and we provide feedback, we have to know and we have to inform them about of these things, because it might affect their time frame, their planning, etc. And specifically, and we found that today when you sell a property to another person, there are a few requirements then in terms of SPLUMA that needs to be first sorted out before that can actually happen. All funds due by the owner must have been paid. So rates and taxes, all contraventional penalties must have been paid. All compliance directives have to be complied with by the client. The land and buildings constructed on the land unit to comply with the requirements on the land use scheme. And in many cases now we found that due to illegal construction, the land use has, or a different land use has been put in place on that property, which is against then the town planning scheme and the land use restrictions placed upon that portion of or that property then by the town planning scheme. And all conditions of approval of any land development application must then be complied with by the owner. From the list received from local authorities, I have established that, you know, that is by far one of the biggest things here that people actually sometimes do not know, especially the owners. And the professionals are then engaged by the owners to act as their agents, because remember, we act as the agent of the client. We also don't sometimes know all of these things, and we advise the clients wrongly, and that actually creates then a lot of problems for both parties later on. Now, specifically, if you are in Mpumalanga, from the 1st of June 2017, the Registrar of Deeds has indicated that no transfer of property will be registered without a certificate issued by the relevant municipality indicating that the SPLUMA requirements have been complied with. There might be a few other provinces that have followed in the footsteps of Mpumalanga, but I know that Mpumalanga was the first one. So you couldn't transfer a property unless you've got a SPLUMA certificate. Doesn't matter what the property, what land use, what's on the property, you have to obtain a SPLUMA certificate. The other provinces, you only require a certificate when there's a change in land use. In other words, if there's a rezoning application, that's a change in land use. If there's a subdivision, if there's a consolidation, etc., then you will require then a SPLUMA certificate, or when you establish sectional title deed or register a sectional title deed on a property. Now, out of SPLUMA, I just have highlighted the following definitions so that when we read all these requirements that we understand what those are. So what is land? It means the earth. It means an agricultural holding or a portion of a farm. And when we talk about land in terms of SPLUMA, it will include any improvement like buildings and any real right that you've got on that land. You might have a servitude that grants you certain permissions. Now, all of that is then defined as land. What is land development? It means the erection of buildings or structures on the land and the change of use of the land, including township establishment, the subdivision or the consolidation of land, or any deviation from the land use or uses permitted in terms of an applicable land use scheme. Land use is the purpose for which the land is or may be used lawfully in terms of a land use scheme, existing scheme, or in terms of any other authorization, permit, or consent issued by a competent authority. And it includes then also any conditions related to such land use purposes. And the land use management system is then the system of regulating and managing land use and conferring land use rights through the use of schemes and land development procedures. So when it comes to SPLUMA and when a SPLUMA certificate is required, what are the important issues that in many cases needs to be addressed? Approved building plans, number one. I think we all are aware of the fact that many tiers are being there are many tiers these days from clients where they have unlawfully erected structures on their land. Now they have to sell the property, and all of a sudden they found out that, you know, they have to get permission or building plans approved, and then they found that the land use management requirements are not adhered to, and rezoning, there might be building line restrictions that have to be lifted. They might have even be title deed restrictions that have to be lifted, and that puts then quite a big break then on the speed in which they have thought that they can actually go and sell the property. The use of the property must be in accordance with the municipal zoning, and there must be also the fact that we have to ensure that there are no encroachments over the building lines and the property boundaries. And it's, you know, it's quite strange actually how many times, especially property boundaries, are encroached. I myself are actually busy at the moment with illegal buildings and a special consent application, and we found actually that there were encroachment on the property boundary by the client. Oh no, it was not him or her, they bought the property like that. But if you go back on Google Earth, that encroachment actually happened after they bought the property. So it was not the previous owner, and so they did not buy the property like that. They actually indeed did this. But yeah, nobody can prove that. Unfortunately, we've got the aerial photographs and Google maps that can, Google Earth that can actually show us these days all these things that might come back and bite us. Now, what is a town planning scheme? That the purpose of a town planning scheme is to enable the comprehensive management of all property and related public sector functions across a municipality through the implementation then of certain general guidelines. And most of the local authorities have got websites these days, and you can go then to your local authority's website and you can download then the town planning scheme from there. For instance, here you can see there's a URL there. I'm just going to click on that and see if I can open it. See, there's a little bit of a delay. I'm not sure if it's everywhere, but if you click on that link, you can actually see there I've opened the City of Johannesburg Land Use Scheme 2018. And in there, you can find all the requirements then of what you need to comply with then for that matter. Okay, let's go back to the slides. The best thing is to Google just Johannesburg Town Planning Scheme, Pretoria, or Tshwane Town Planning Scheme, or whatever it is, and you can find it there, and that will give you then the requirements that you need then to comply with. So what does a town planning scheme then actually regulate? First of all, zoning. Why is zoning important? It ensures that you will not have a development next to, let's say for instance, a residential house that will generate noise, air pollution, or something like that. So zoning applications there, or zoning are there basically to ensure that what belongs together are put in a certain area, and if it doesn't belong together with other types of developments, that it's then separated from that. Another thing that we also look at is the FAR, the floor area ratio. That is all to do with density. Read that together with the coverage. So FAR, coverage, and density basically talks to the same thing. Then in many cases, there are height restrictions. Some of the town planning schemes might have a very specific way of how to calculate the maximum height of a building, while others are quite easy to comply with. And another thing that it might cover will be then the requirements for parking for certain types of developments. Now, as you can see, these things are not covered by the building regulations then, but these are things that when we design a building, we have then to comply with as well. Looking then at what is zoning. Zoning is a system implemented by different levels of government to effectively organize and to regulate the use of land within a specific area. It serves then as a tool for better control and governance of land development. You don't want an abattoir to be built next to your multi-million dollar or rand house. Okay. And through zoning, land is divided into designated zones or categories, each with its own set of regulations and permitted uses. The system then helps to ensure that land is utilized in a manner that aligns then with the intended purpose and promotes then orderly as well as sustainable development. Here is just a screenshot out of a town planning scheme, the use of zones, for instance. There you can see residential 1. You will see how it's been noted on the town plans itself. The primary land use rights has been given, which is a dwelling. Then there are secondary land use rights that might be allowed under special consent, for instance. And then there are definitely prohibited land uses, with other words, uses where that property cannot be used for. Then we come to coverage. Now, coverage is the building footprint on the stand. In other words, what percentage of the stand is covered by a roof? Paving, driveways, swimming pools, and boundary or garden walls do not count towards coverage in South Africa. So you look at the footprint of the building. Doesn't matter how many stories the building have, but if you look from top, what percentage of built-up area is covered? Is that land then covered with? With other words, where there's a roof over it, that counts then towards coverage. Then we come to floor area ratio. Now, that is the percentage of living space available on the stand. That will include then bedroom, lounges, kitchens, or workers' quarters, for instance. Types of uses in the building that are excluded from that will then normally be garages, covered patios, lapas, sheds, swimming pools, and storerooms. So for instance, if you've got an FAR of 0.6, it will effectively ensure that the first floor is smaller than the ground floor if you look, for instance, at a double-story building. Or it can actually be the same size, but then the ground story will be also much smaller to make sure that your double-story part counts then towards that. And because garages, covered patios, and stuff like that, lapas are not included in here, obviously all ground story, the total ground story buildings, if you look at the floor area, will be much higher than that of second or third stories. Then what is a building line? That's a line that is a fixed distance from the boundary of an earth or a property abutting a public and or private street or any other boundary of an earth or property, and it may include then a flat water mark where it's indicated as such on the zoning maps. And again here, don't just assume that if the town planning scheme say that the building line is X meters, that it will be indeed only that. There might be a restrictive condition in the title deed that might require a much bigger distance, and that means that that must first then be resolved and going back into the building line. The building lines are there for a purpose. You know, in the good old days, that was the space allowed next to buildings and the boundary for the emptying of the buckets from toilets, etc., in the past, so that there's unobstructed passage for those people that have to do that unfortunate job. Later, it's also a requirement that if we, when it comes to the fire safety distances, that we automatically will comply with that and not have to do a lot of calculations to show that we comply with that. So if you do a relaxation of a building line, basically what happens then is that you have to get the next door neighbor's approval. That is the reason for that. But the next door neighbor must then remember that in many cases he's given away some of his rights then for future development on his property. For this instance, I just want to refer you to a very interesting court case, Simca Trust versus City of Cape Town. Go and read through that. You can get it on the internet, and you can actually see that, you know, that the courts are actually looking at the, certain expectations that are these days created rather than fixed rules and stuff when they deal with certain issues. Then we come to the title deed. Now, the title deed usually have restrictive clauses within them, which could affect the outcome then of your building plan application, such as a 2-meter servitude, for instance, on 2 boundaries other than a strand boundary, street boundary, or a panhandle. So that's in the title deed. It's restrictive conditions, and that will override any other town planning requirements, etc. If the town planning requirements are lesser than what is in the title deed. It also may contain further restrictions such as prohibiting metal roofs or wooden buildings or certain building occupancies then on that property. So here I've just got one here. To make that a little bit bigger there. And there you see there, for instance, no trade, business, industry, manufacture, process, or occupation shall be carried on upon the said land if, in the course of trade, business, industry, manufacture, process, or occupation, any offense of liquid or wastewater is liable to be produced. And if you go to the top one, just want to scroll a little bit higher. It shall be of stone, burnt brick, concrete, or any other permanent and fireproof material, and shall need of appearance and conforming to municipal bylaws. So this is typical restrictive conditions. What we found many times is that it also states that, especially on a residential property, no trade, business, etc. may be done from that property. So that means then that you can't have an Airbnb, a B&B, or etc. unless you then remove that restrictive condition. So that is also the reason why the majority of our local authorities are actually requiring us then, when we submit, especially the site development plan to them, if they require such, a copy of the title deed, so that the restrictive conditions, they can check if there are any restrictive conditions that needs to be lifted or that will prevent that development then from taking place. Then we come to the surveyor diagram, the general diagram, and that is a fundamental document. It's prepared by a professional land surveyor. It is registered with the Surveyor General, and that basically then give you the cadastral data then of the property, the coordinates, the description of beacons in many cases, etc. If you're not aware of the fact, there is a URL there that you can go and click on. Just making sure, see if I can actually connect to that. I see there's a little bit of a delay. Okay. I'm just going to go back to the presentation, but as you can see, there is the URL. If you go in there, it's quite easy. You just select your province, you give the earth number, and then you will basically get a TIFF file with the title, with the SG diagram on it. And here are two examples then of SG diagram. Now, the one on the left-hand side, you can still see comes from the era when the Suid-Afrikaanse Republiek was still in place. And that is still a valid and legal SG diagram that it was obtained from the Surveyor General's office. So it doesn't mean that it will be metricized, whatever it is. And you can actually say here, I can see here that the dimensions is in Cape feet, and that the area is indicated as Ruden. On the left-hand side, you've got a more recent one. Coordinates being given, servitudes, as you can see there, indicated, the SG number, etc., all of that on that. And that gives you then the correct dimensions, shape, restrictions, whatever it is on that property. And it will also show previous consolidations done on that property. Then we come to the guidelines of estates. Now, estates may have guidelines from the aesthetics committee, body corporate, residence association, etc. But remember that such guidelines must also then comply with Section 33 of the Constitution if it restricts rights. It contains a list of requirements that ensure aesthetic harmony and good building practice within the estate or the complex. And plans must be stamped in a letter from the HOA for council indicating that they are happy then with the planned building. However, as I can see there, it cannot override legislation. So an estate guideline cannot impose restrictions and thereby override legislation. Just to give you an indication now here, a draftsperson is allowed, for instance, in terms of the IDFW, to design a single-story building or a dwelling. So an estate cannot come now with a restriction and say only certain people can do so, because then they will be in transgression of Section 33 of the Constitution. And that is actually not a nice thing, or it can have quite big consequences for them in the end. Then we come to the site development plan. Now, quite interesting here is that if you go and read some of the town planning schemes, they say that they do not need the site development plan if it's for single residential developments, for instance. I've read one or two that actually say that. So make sure that when you do a building on a property in a town, that you know what is required in terms of the town planning scheme, so that you do not unnecessarily have to comply with requirements where people indeed read the requirements wrong at the local authority themselves. So what is a site development plan? It's the implementation of all improvements that are needed for a site before construction may begin to show compliance with the scheme. That is the purpose of an SDP. How do I comply with the town planning scheme? How do I comply with my land use management requirements? That is a SDP. That is what it is actually doing. It may include then a landscape architectural plan and a detailed engineering drawing of proposed improvements to given earth, for instance, stormwater drainage. A site plan usually shows a building footprint, travelways, parking, drainage facilities, sanitary sewer lines, water lines, trails, lighting, and landscaping and gardening elements. It's a graphic representation of the arrangement of buildings, parking, drives, landscaping, and any other structure that is part of the development project. And it's not an in-detailed structural design type of thing. So just show how is this property going to be developed, and how is that development when it comes to material use, etc., going to comply then with the town planning scheme. Now, one of the things that, and this is from one of the plans, I actually hate to do that, but I need to give some examples. When I submit a building plan to a local authority, I've always got a little summary of how I complied then, for instance, with town planning restrictions when it comes to FIR, the area of buildings, the height restrictions, provide the zoning there, because it's quite important, because the zoning, both in terms of SPLUMA and in terms of the national building regulations, will then require you to comply with the zoning will basically show you on how to comply with SPLUMA, if you comply with SPLUMA. And the NBR classification that I've got on here will show you which regulations will then be applicable to the building plan submission and the development itself then. Next, we're going to move over to the National Building Regulations and Standards Act. But I think let us give ourselves a little bit of a break here. It is now 11:41. If we can all be back at 12 o'clock for the second session then of this first session on issues that local authorities have and how we have to comply. And then the next session, then we're going to deal then specifically with the national building regulations. Thank you. Okay, it's 12 o'clock. Let's continue then. And the next session, we're going to look at the National Building Regulations, the Buildings and Building Standards Act, the building regulations, as well as a few issues in SANS 10400 Part A then, where it comes to building plan submissions. So the national, just a little bit of a history, a background history about the National Building Regulations and Building Standards Act. Now, that is the enabling act under which the national building regulations are made. In other words, that is the act that basically say then that the minister can make regulations, which we know then as the national building regulations. Now, there are 3 points in particular which should be borne in mind when we consider then the relationship between the act and the regulations that are made under the act. And I just want to highlight this, the first one, because it is quite often used in the wrong context, because people do not go back to definitions and make sure that what they see there are actually what they read. Remember, the Act was written in 1977. It became enacted in 1985. So it's still old wording and old terminology that is still part of the National Building Regulations and Standards Act. So when you see the word council in the National Building Regulations and Standards Act, it does not refer to the municipal council. Municipalities are referred to as local authority. So what is council then? Now, council, if you go and look at the act itself, it refers then to the definition of the word council as per the old Standards Act. But the Standards Act was reviewed in 2008, and the regulatory functions given to the South African Bureau of Standards were taken from the South African Bureau of Standards and given to the National Regulator of Compulsory Specifications. With other words, the old SABS or the old Standards Act was split in two, the Standards Act, the New Standards Act, and then also what we refer to as the NRCS Act. And the council then will be then the board of the National Regulator for Compulsory Specifications. Now, we know that the board has been disbanded. I'm not sure if there's a new board. So in general, when we see the word council, then it will mean the National Regulator for Compulsory Specifications, and which is then giving advice to the Minister of the DTIC about the National Building Regulations. Now, it also contains certain sections which in the past would have been contained in local authority bylaws. And the Act quite clearly, or the regulations then published under the Act, will say that all these old building bylaws by local authorities, when the National Building Regulations came into play in 1988, were actually repealed. With other words, it's not in place anymore, because it is seen that the building regulations, in most cases then, have indeed replaced all of these bylaws. And if a bylaw was not specifically, or the content of a bylaw was not specifically then mentioned in the new building regulations, that's now the 88 version of that, it means then that it was deemed not to be relevant anymore. Pardon me for a second. Okay. But it also means that not all bylaws were actually replaced by the National Building Regulations, because there might be special circumstances in a specific area which require the use then of still older building bylaws. So again, there it is just a matter of going to do a little bit of research and make sure that the building bylaw, if it was promulgated before the promulgation of the National Building Regulations in 88, are not one that is actually counter to or repugnant, as the building regulations call it, to the National Building Regulations. So because the Act is more than just enabling legislation, it is important for us to realize that the Act and the regulations should be read together. and we should read every regulation in context with the requirements of the Act and in general then with the regulations. We found quite a number of times that professionals and local authorities take a clause out of the regulations, and if you just read the clause, other meanings can be put to it than what it's actually want us to then to do. So a little bit of history. The Building Regulations and Standards Act, which we all know as Act 103 of 1977, was published in June 1977. But it took 9 years for a promulgation notice to be published in the Government Gazette to say that it will come into operation on the 1st of September 1985. So prior to 1 September 1985, what we have in place, not the National Building Regulations and Standards Act, but the old bylaws of the local authorities. As of the 1st of September 1985, then only the Act came into play. And it's only from then on that local authorities could actually then ask for compliance with aspects of the National Building Regulations and Standards Act. I believe it's in next week's session that we will also deal then with the fact that regulations and acts cannot be retroactively applied, and how we should deal then with older buildings, especially when it comes then to occupancy certificates. Now, the Act prohibits construction of buildings within a municipal area without prior approval by the relevant municipality of the building plans. Again here, go back in history, under the old demarcation or the old way that we dealt with things, local authorities only had jurisdiction on the towns itself, the peri-urban farmland and trust areas, etc. The old independent areas or dependent areas were excluded then from the municipal jurisdiction. But the Act said that all buildings have to comply with the National Building Regulations. The only issue at stake here is the submission to the local authority for approval. So if you've got a building on farmland, doesn't matter when it was built, it had to comply as of 85 with the National Building Regulations. The only aspect was it was not required to be submitted to a local authority because it fell outside the area of jurisdiction of the local authority. But for health and safety sake, those buildings still had to comply with the requirements then of the regulations. So a person then now wishing to erect a building in a municipal area is obliged legally then to first apply for approval of building plans from the relevant municipality before they can commence with construction. And I want to highlight again here what I've said earlier. If you go and read a few of the judgments made in the Constitutional Court, especially by Judge Jafta, it is said then that that non-compliance with the National Building Regulations constitute a criminal offense. A lot of people have tried to water it down to say it's only an offense, so it only means that you maybe get a fine, etc. But to be honest, the National Building Regulations say that that the maximum fine imposed can be 1 year imprisonment or a fine of 4,000 Rand or both. Now, don't be now happy about 4,000 Rand fine. It goes back to 1977. We've got the Adjustment of Fines Act. So a 1 year imprisonment, I think, equals about 100,000 Rand fine today, or you can actually get both. So it can actually cost you quite a lot, and you might even get a demolition order if it doesn't satisfy then certain requirements of the local authority in terms of the National Building Regulations and Standards Act, as well as SPLUMA. Who must comply with the Act? The owner of the property. The owner shall, in respect of the erection of or proposed erection of a building with regard to which an exemption contemplated in subsection 4, 5, and 6 applies. Now, I just want to stand still, first of all. Who is responsible? That's the owner. Now it goes further to say, if that owner, and that includes now state buildings, that is clause 4, 5, and 6, key points, etc., where there is electrical supply, water supply, sewer, and storm drainage systems applicable, or where you need, in terms of a town planning scheme, to provide parking for more than 100 motor vehicles, or where the services of the local authority's fire brigade is in place, or if there's an addition to any fire protection service provided by the owner, that owner then have to supply the local authority concerned with sufficient details to enable then that local authority to provide a connection, road traffic control, and fire brigade service which may be required, and or he must give notice in writing to, that they cannot, that's now the local authority, that they cannot provide such service. So the Act do allow for certain times when plans have to be, do not have to be submitted for approval or refusal, but only for comments. But there is a specific requirement on all of these that the details then have to be provided so that those services can be connected then to the building. The Act also have a section, that is section 3, that deals with the duties of draftsmen, meaning architectural professionals in today's terminology. And it says that any person who prepare a plan, a specification, a document, or a diagram must affix his name and address. And if you are an architectural professional, a land surveyor, or a registered person, which in this case means then professional engineering professional, his profession and registration number. Okay. To such plan, specification, document, or diagram. So the person who takes responsibility for an architectural project, the plan submitted to local authority, although the SACP Code of Conduct say that you can only supply the practice name, the National Building Regulations and Standards Act do require the registration number as well as the category of registration then of that person to be on the building plan. Section 4 prohibits then the erection of a building if there's not prior approval provided in writing by the local authority. And the application then made for the approval of such a plan will be then in a form made available by the local authority in question. Now, this is not Form 1, etc., as we've got today. Again, I will deal with Form 1 next week, but Form 1 is a declaration on how you're going to satisfy the building regulations. But the local authority, for their administrative purposes, may have hard copies or online forms and stuff that you have to complete when you submit in a building plan to them for consideration for approval. This application must contain the name and the address of the applicant, with other words, the owner in many cases. And if the owner is not the applicant is not the owner of the land, on which the building in question is to be erected, the owner of the land. So in any case, in all cases, the owner of the land's details must be provided on the building plan. And it requires that the application must then be accompanied by by plans, specifications, thing that we try not to do because we think that a plan submitted to a local authority is not, it's just a line drawing or something like that. documents and information as may be required by or under this Act, and by such particulars as may be required by the local authority in question for the carrying out of the objects and the purposes of this Act. Now, we will see if we carry on later on. I know a lot of people talk about municipal submission drawings and then construction drawings. The only difference between a municipal submission drawing and a construction drawing that's issued to the contractor is that there you will provide, for instance, details for things like cupboards and stuff, which is not an issue on a plan for a local authority. But all the other details, structural foundation, whatever it is, those are specifically or may be specifically required by a local authority to form part of the building plan. With other words, go back to what I've said earlier. What is a building plan? Why do we submit a building plan to a local authority? Because you want to communicate through your drawing to the local authority how you have complied with the building regulations. With others, you must show through specification of material use, details provided, etc., how you have satisfied the different aspects of the building regulations. Then we come to Section 7, and Section 7 ended up quite a few times in the Constitutional Court, and the courts have given basically effect then to what is in Section 7 of the Act. And Section 7 basically deals with the way in which a local authority have to approve a building plan, and it puts a requirement, a legal requirement on a local authority to refuse the approval of a building plan in certain cases. So if the local authority is satisfied that the application complies with the requirements of the Act and any other applicable law, and here we can quickly think about SPLUMA, the National Heritage Act, maybe some Conservation Act, etc., they must grant its approval then for that. So if they satisfied that everything is done and you have communicated to the local authority with enough detail for them to make such a decision, then they have to approve the building plan. However, if they are not satisfied, with other words, there are not enough details, you haven't proved to them so that they can see how do you indeed satisfy the building regulations in many aspects. Or if they are satisfied that you've done that, but that the building will be erected in such a manner or be of such nature or appearance that the area in which the building is to be erected will probably or in fact be disfigured thereby. It will probably or in fact be unsightly or objectionable, and it will probably or in fact derogate from the value of adjoining or neighboring properties. Then, or it will probably or in fact be dangerous to life or property. The local authority must, with others, there's a legal obligation placed on them to refuse then to grant its approval in respect thereof. And they have to, and we have seen it earlier on in terms of section, I think the 36 of the Act, of the Constitution, then provide you with written reasons why they have refused your approval. So you may comply in all aspects with the national building regulations. You may in all aspects comply with SPLUMA. You may in all aspects comply with heritage legislation. But there might be some other aspect which they have to take into consideration. It might be unsightly, it might be dangerous, or whatever the case might be. And the new way, and that is specifically what I've highlighted earlier when I mentioned Simca Trust versus City of Cape Town, there might have been an expectation created by the next door to the next door neighbor, and although you comply in all aspects then with all the legislation, they have then also to refuse you permission to do what you are legally entitled to do. So it is not a given that you can actually do so or will get approval. And for that matter, then they have to give you written reasons why they do not comply with that aspect. Now, what you see also here is that the local authority has got two options. They can grant you approval or they can refuse your approval. There is nothing in the Act that say that they can refer the plan back to you. If a local authority does that, they actually shoot themselves in the foot because they have got a limited time period to either to approve or to refuse a building plan. And if they refer it back to you, they did not refuse it and they did not approve it as yet. With other words, the clock doesn't stop ticking. The clock carries on. And if that period then exceeds the period provided for in the legislation for them to either to approve or to refuse a building plan, they are committing an administrative action that is not just. So a local authority, and unfortunately that thing has crept in, and I think that is the biggest issue that we have, and I hope local authorities also realize that. You either refuse or you approve. You don't refer because there's no legal backup for a local authority where it comes to referrals. There's no case in law to say that they can refer a building plan. If a building plan is not correct, it's refused. And if it's refused, the Act provides for the fact that you can, within a period of 12 months after the date of refusal, resubmit that building plan with the corrections done without paying any other fees, and then it might go through the whole process again and it might then get approved, or if you haven't done your job properly, it will get refused again. But that's a new submission process then. Okay, so we have started, and I think that was to please people and to make just things nice. And unfortunately, the necessities have gone through the back door in many of these cases, and now it's a fight all over. And we've got such an administrative nightmare now created by especially the local authorities, where they come to refusals or other and plans that they call some other names like rider plans, and I've heard a lot of names of these things lately. But there's no case in law for that to actually happen. So it's either an approval or a refusal. Now, I've mentioned time limits. The Act stipulates that the local authority must approve or refuse a building plan if it's less than 500 square meters within a period of 30 days. If it's more than 500 square meters within a period of 60 days after receipt of the application. So if I submit my form to the local authority and they accept that, they have received my application. If they've got a process in place that they have to invoice you first and then you have to pay the invoice, there's nothing about that you have to, that the clock only starts ticking after you've paid the invoice. That is after receipt of the application. If their administrative process is so that payment happens later on, then they have to fix their administrative process. But when you submit, and electronically these days, it would have, I think it's the Electronic Communication Act that stipulates that once you have submitted something online or electronically, 24 hours after that, day one starts to count. That's that. Now, what is this 30 and 60 days? Is it calendar days? Is it weekdays? Is it business days? Whatever. No. And I forgot now, pardon me, the specific name of the Act. But in law, it means Mondays to Saturdays, excluding Sundays and public holidays. So Saturdays are inclusive of this 30 days in terms of the law. Even if you don't work on a Saturday, bad luck, the Act say, because it's not stipulated their business days or calendar days, therefore that requirement of the Act will come into play, and that means it includes Saturdays. Okay, let's move over then to the National Building Regulations itself. Now, we are going to deal with the standards in session 3 and in session 4, with more pertinently. But I just want to say something now here. We've got the National Building Regulations and Standards Act. That's legislation. We've got the National Building Regulations. That is legislation. Then we've got SANS 10400. That is not legislation. That is a way that we can use to satisfy the building regulations. And hopefully I will explain it so that you understand it during this next few minutes. Now, again, a little bit of history. Amendments to the National Building Regulations come into play on the 1st of October 2008. There was quite a few before that, but I think in recent history, I think most of us will remember the big or the quite rather huge revision of the building regulations that came into play in October 2008. And the time was also just ripe for that to happen, and also it happened on the correct time period, because as you can recall, CPD became compulsory in 2008. Actually, 2007, it was a year extension granted. So when the voluntary associations looked for something to do CPD with and to provide CPD, whoops, there we've got the National Building Regulations that's just now fresh out of the oven. Not all the standards were even done as yet. So most of the VA started then with the NBRs as part of their CPD. And personally, I thought that we're going to do it for about 2 or 3 years, and then we will be done with it. And what's it now? 2024. And here I sit today here at SACAP, and I still do CPD on the National Building Regulations. The other big amendment to the regulations came in place on the 9th of November 2011, when XA was introduced into the National Building Regulations. Now, if you go and read through the building regulations, it consists out of 24 parts. It contains a total of 106 sub-regulations. And these sub-regulations are then divided into prescriptive regulations. With other words, we have to comply with those regulations. And then there are the functional regulations. Now, the functional regulations are the one then that we can satisfy then if we use, for instance, SANS 10400 as a vehicle then to satisfy that. But there are other vehicles as well available for us to satisfy the functional regulations. Now, what is a functional regulation? It's a regulation that sets out in qualitative terms what is required of a building or a building element or a building component in respect of a particular characteristic, without specifying the method of construction, dimensions, or materials to be used. If you go and look at our prescriptive regulations, it say, this is what you have to do, full stop. It doesn't say, to do so, you can go to a 10400 standard and you can do what the 10400 do, or you can apply any other means as long as you comply with the performance requirements as set in the standard. No, in this case, it say, you do this and that's it. Let's look at I'm just going to use an example here quickly. Regulation S1. I know a lot of people don't like Regulation S, accessibility. Regulation S1 say these buildings have to comply. Full stop. Can't do a rational design to get out of that. Okay. It's just like if you want to drive 80 kilometers in a 60 zones, you can't go to your local speed cop and ask him for a letter stating that that he gives you permission to drive 80 kilometers an hour. It can't happen. So the same happens with the prescriptive regulation. You can't do anything else to get out of the legislation. You have to comply with the legislation. But if it's a functional regulation, it say quite clearly, to satisfy this, you can use then either the deemed to satisfy or the performance requirements in 10400 to satisfy that. This is I don't know what your picture that was provided to me by one of the previous regulatory writers at the NRCS a few years ago. So we've got the Act and the NBR. They're in the yellow part on top. On level 1, that is the objective. What is the objective of the National Building Regulations? To provide for uniform application of building regulations in all areas of jurisdiction of local authorities and to provide for regulations regarding that. Okay, I'm just going to give a few minutes for the poll. Okay, so that's on level 1. On level 2, you've got the functional regulations. Obviously, the prescriptive regulations as well. And those are in the National Building Regulations. Now, to change that is quite a big issue. To change an act, the minister must submit a proposal to cabinet. The proposal gets then approved, and then he submit that proposal as a bill to parliament. There it goes to the two houses of parliament, the National Assembly and the House of Provinces. Both of them have to approve that proposal after a public participation process. Then it goes to the president, and if the president is happy, he will sign it into legislation, and then a promulgation will be published in the Government Gazette stating from which date it will become effective. Time period here, 4 years plus. Regulation goes to the minister responsible for the management of that act. He then issue a regulation, first draft regulations that must be public for public comment. And then once the public comments are received, then it can be published as a regulation. Time period here, anything from 3 months to a year, if we are lucky. So it's not something that we can overnight change, and that is a consultative process. With other words, government consult, but they do not necessarily have to accept the views of other parties, etc. Obviously, they have to make sure that that their way is constitutionally correct, but it's a consultative process. Then we go to the 10-400s. That is where we get the performance requirements published in the standards. With other words, these are the minimum requirements that a building or a building element or a building component have to comply with. And normally what happens here is that reference is made to other codes of practice or standards. Like in engineering, they will refer to 10164, 10100, etc. But the engineers then use to do rational design. So rational design is must then comply with the performance requirements as set in the standard, because you can't just leave it open there for anybody, because then anybody can design whatever he wants and just call it a rational design. So you must show then still compliance with the minimum requirements, but through different processes, which he then have to prove that he does so. The other way is the so-called deemed to satisfy solution. And that is where a committee at SAPS or a work group has been established under a technical committee. They sit down, they reach consensus on a solution or solutions then that satisfy the performance requirements. Then that gets published also after a public comment period. And then the regulations say if you comply with those rules in a 10-400 standard, you are deemed to satisfy the regulation. And the same with a rational design. If you can prove that you satisfy the performance requirements as stipulated in the standard or other codes of practice, then you are deemed to satisfy the regulation. Okay. So we get the 4 ways of doing it. We apply the rules that we've got in 10-400 and also the construction requirements in 2001 series. Once we've done that, nobody can come back and say, you need to do something else, because we are deemed to satisfy. Or you can do a rational assessment or a rational design. That is done by a competent person. More about competent persons next week. And once that you have that competent person then have established through rational assessment or rational design that they comply with performance requirements, then that complies with the building regulations. And then lastly, we've got third-party certification, similar to a rational design or rational assessment, but that's where a manufacturer goes to Agramo South Africa, for instance, build a prototype of their product there. Agramo South Africa then basically break it to determine what are the levels that of failure, and if that levels of failure is above the performance requirements as established in other standards, etc., then they will certify that as fit for purpose. Agramo certification you will only get for a product or a system where there is not an existing standard in place to cover the performance of that material, system, or whatever it is. So it's for new innovative stuff. So if you do a steel structure, you can't do an Agramo certificate for it because there's already standards dealing with steel structures. How do we satisfy the building regulations? And this is where we have to understand the meaning of regulation AZ4. AZ4, and I think I've already dealt with it, but let's go over it again, say that you have to adhere to the requirements of all the prescriptive regulations. Those regulations that say you have to do this and that's it. Okay, you can't do anything else. The regulation itself, if you go and look at that sub-regulation, it will not say to satisfy this, you can go to 10,400. It just say you have to do this. That's it. It gives you a quantitative requirement to comply with, and not just a qualitative requirement to comply with. So it's a rule-based regulation where the outcome is fixed in advance. No alternative methods than those given in the regulation, and compliance with these rules are compulsory. It's like if you see that little sign next to the road that says 60, if you go over 60, there are consequences. In this case, if you break the law here, if you break that rule, there are consequences. Then you can adopt, adopt the building solutions that comply with the requirements of the relevant part of SANS 10,400. That is the deemed to satisfy requirements. It's not prescriptive. Although people call it the prescriptive requirements of the 10,400s, I think the wording there is unfortunate because a lot of people confuse it with prescriptive regulations. So the requirements here is, if I do this, I am deemed to satisfy the regulation, but I don't have to comply with the 10,400. And I think it sounds strange now. I don't have to comply with the requirements of SANS 10,400 Part T. I don't have to keep with safety distances, but I have to do a rational design and prove that whatever I then suggest in place of the deemed to satisfy requirement, let's say for safety distances, will give me an equal or a better outcome. And that must be based then on standards and stuff that are already in place, can be national or international standards, etc. So compliance with SANS 10,400 deemed to satisfy requirements is not mandatory. It is a way that I can use to satisfy the building regulations. And that means then that when it comes to the design of buildings, we are not technically over-regulated like a lot of people say, because we can still do our own thing. The only thing that we have to do through a rational design is to show that the outcome, the performance of that building is equal to a minimum performance. I can go way over that. Indeed, in complying with the deemed to satisfy might sometimes be so that it is more expensive, because a deemed to satisfy requirement in a standard have to cater for all criteria, all circumstances. It's basically a one-fits-all solution and not specifically designed then for a specific purpose. Then I can reliably demonstrate or predict with certainty to the satisfaction of the appropriate local authority that an adopted building solution, with other words, another solution that's not the deemed to satisfy, complies then with the performance or is superior to the performance as stipulated then in a certain part of 10400. Okay. So if you look, for instance, at structure, the structural requirements, I'm just going to mention one standard there. If I can prove that my performance is better than the performance requirements as stipulated, let's say in 10164 or 10162, whatever the standard is, I as an engineer can then say quite easily, I have proved to you that the performance will be equal or better to that industry accepted standard, and therefore I will satisfy the national building regulations through my rational design. So a rational design, the question is now, what is the difference between a rational design and a rational assessment? A rational design is a design by a competent person involving a process of reasoning and calculation, and which may include then a design based on a standard or any other suitable document, whereas a rational assessment is an assessment by a competent person of the adequacy of the performance of a solution in relation to the requirements, including as necessary then a process of reasoning, calculation, and consideration of accepted analytical principles based on a combination of deductions from available information, research and data, appropriate testing, and service experience. Example, structural engineer. I do not comply with the masonry wall requirements as stipulated in Part K, the deemed to satisfy. My distances are much longer, my heights are much higher. So I go to an engineer, he used then the standard for masonry brickwork, and he do a rational design based on the performance requirements in there, and he proved that whatever he did then will satisfy the structural requirements of that masonry wall. But what about a straw bale wall? We have got no performance criteria or design standards or codes of practice for straw bale walls. So in that case, you must do it through testing. You might have to go and erect a test wall, do some tests as prescribed, for instance, in the regulation B then, on those to determine failure points. And if those failure points are then above a certain limit, he can then say, I've assessed that this wall will withstand all these forces that can work into it, and therefore I say that it is okay. Another assessment is if a building is already erected, and then a visual assessment and sometimes some testing is required then by an engineer to determine that whatever is already standing there will satisfy certain performance requirements. Now, in 2010, when Part A, 10400 Part A was published in its new format the first time, they've included in the standard. So it's not a regulatory thing, this one. It's a standard requirement, a Category 1 building. Now, that is just to put another set of rules for compliance to the national building regulations, not all of them, for certain types of buildings to make it a little bit more economically to erect, to cater for then, especially for sub-economic housing, etc. And in the main criteria for that is that it cannot exceed 80 square meters. Now, a Category 1 building is then a building designated as the following occupancy classes: A3, which is education; A4, which is worship; F2, small shops; G1, offices; H2, dormitories; H3, residential buildings; H4, dwellings. If you cannot have a Category 1 building in any of the other building occupancies, it's only those 1, 2, 3, 4, 5, 6, 7, if I count correct, that can have a Category 1 building. Further, that building cannot have any basements, and the load-bearing walls carrying the roof cannot be more than 6 meters apart. With other words, roof spans cannot exceed 6 meters, and I've already mentioned then the 80 square meters. Now, it is not automatically that such a building will satisfy or will be then regarded as a category 1 building. You can, let's say, for instance, for structural design, it is a normal building, but for energy efficiency might comply with the category 1 requirements for energy efficiency. Okay. And it's not all aspects, like I've said, all parts that will say that can be a category 1 building. There must be specific requirements for category 1 buildings in a specific standard. And then you have to indicate that you're going to use that on your title block, that it's a category 1 building. And we will deal with that in one of the other sessions. Okay. Now, what must be on a building plan when I submit it to a local authority to satisfy then the national building regulations? Now, first of all, before you submit to building control, the land use management issues had to be sorted out. Okay. A dear friend of mine, Rudolf Opperman, who was at the NRCS right in the beginning here, when I got involved in all of this in 2008 round, said to me, and he came from the building control environment, that when you submit a building plan to building control, the clock will only start ticking for building control requirements in terms of the National Building Regulations and Standards Act if there are no outstanding land use management issues. So you can't go and submit a building plan to building control and you've got a rezoning application still at hand, or you're still waiting for the outcome of a building line relaxation, because it means then that building control cannot approve such a plan based then on what might happen in future, because you might not get the building line relaxation, you might not get the rezoning, whatever the case might be. So once your town planning issues are being resolved, and I think here we must be very clear and you must actually say to clients, or make sure that clients are aware of this, that we then submit to building control. And that is where SDPs are actually coming in then, where we show compliance then with the town planning scheme, or where we do all these applications. And one that's obtained, then we submit it to the local authority as part of the SDP to show that we comply, get an approval of the SDP, and then we submit it, if that local authority works like that, then for building plan approval purposes. So under Regulation A1, the designing, the planning, and the supervision of the erection of any building or structure, or the performance of any function in connection therewith in terms of these regulations, is subject to the provisions of any law in terms of which the person undertaking such work or performing such function is required to be registered, in terms of the Architectural Profession Act, the Engineering Profession Act, the Natural Scientific Profession Act, or Professional and Technical Surveyors Act, or any other act where that person performs then a design function, based on basically the law that then governs his or her registration. So if you submit a building, if, for instance, the Architectural Profession Act do require that architectural work can only be done by a person registered in terms of the Architectural Profession Act. So that means that when a building plan is submitted to a local authority, only an architectural professional can do so. There are certain exclusions where engineers can do so, where the main function of that building, it might now be a substation, and the architectural portion of that work is minimal, that the engineer can do so, but that will depend then on how the local authority then interpret the Regulation A1. The plans and the particulars in the respect of a building to be erected by or on behalf of the state. Sorry, I'm keeping quiet now here. I just wanted for that to sink in. That is what the regulations say. Shall be accompanied by a certificate signed by the head of the State Department, the minister or his delegated authority, setting out in full details as to the respect in which the erection will not comply with the requirements of these regulations. That is now not where it comes to the submission of the building plans, because remember, even if it's the state, building plans still have to be submitted to the local authority in terms of the Act. And the Act is quite clear here where it comes to justice, police, military, and it's another one, justice, police, military. That you do not, that you might, if the minister, with concurrence then of the Minister of Defence, Police, etc., then issue a certificate that that plan will not be submitted for information to the local authority due to security issues as such. But if the state building is in certain aspects not going to comply with an aspect of the national building regulations, let's say it's a school, the Minister of Education, it's a hospital, the Minister of Health, then they must issue a certificate to the local authority explaining why they will not be able to comply with the requirements of these regulations. And that is actually going to be very difficult with our constitution now at the moment, which guarantee everybody a health and safe environment. So if those requirements are related into health and safety issues, obviously that cannot happen. It can only happen where it does not going to affect the health and the safety of the occupants or the users of that building. Additions and alterations. No person shall erect any building which is to be structurally supported by an existing building, a lean-to, extension of the roof, or extend an existing building, unless an approved competent person, that basically refer to a structural engineer, has judged the existing building to be capable of carrying any additional load arising from such erection or extension. So if you do alterations and additions, and you do not submit a report from an engineer, an assessment report, not a form 1 or a 2 or a 3 or 4, an assessment report where the engineer have put down his observations on paper and have concluded there that it will not affect the existing building, then what you have submitted to the local authority is insufficient in terms of legislation. What if it's a partly erected building? You know, the Building Regulations and Standards Act do put timeframes on the completion of buildings. And if there is a stop in construction for a period exceeding a certain time, it needs to be submitted then as a new building. So in this case, it will be then regarded as an existing building, and an assessment report on the half-completed structure then also needs to be submitted. Why is it like that? Let's say that you are going to add a lean-to an existing building. Okay, on the one part, that lean-to will have its own wall or columns to carry the loads down to the ground or the foundations and then to the ground. But the other part, the other side, is going to make use of the existing wall or the existing column, whatever the case might be. So in this case, the engineer must then make sure that that existing wall or column, which now becomes part of the new structure, is going to be of sufficient strength to carry the combined loads of the existing as well as the new portion of that building to the ground, to the foundations to be dispersed into the ground. And in many cases, the local authority can actually ask then for a complete rational assessment for the adequacy of such structural support. My advice is that that we actually make sure that we get, or that in stage 1, we already where it's additions and alterations, and there's going to be changes to the roof and etc. That we get, or that we require our client then to appoint an engineer for that purposes as well. No plans, particulars, or approval shall be required for any repair which has become necessary as a result of ordinary wear and tear, or which is undertaken in the normal course of maintenance or upkeep of any building, provided that where such repair will affect the structural loading or is a repair of any part of the structural system, the local authority may require drawings or specifications to be submitted. Again, based on a court case here, if you replace what is there with what it was previously. So if you replace timber or wood from windows with wood windows, fine, no plans are required. But today we've got envelope requirements as well in place. XA, for instance, so if you replace a timber window frame with a steel window frame or an aluminium window frame, you did indeed alter the envelope of the building. You did not keep it intact or similar to what it was previously, and court case now say that plans needs to be submitted showing compliance with part XA, for instance. Minor works. Now, a lot of people think that with minor works, you can just carry on. No. With minor works, you have to make an application to the local authority, to the building control officer actually. Okay. And it is then him or her that will decide if the application is okay and you can carry on with the work, or he or she might decide that certain details must be provided to them to support the application, or they may actually require full building plans for that minor work. So it is not a given that minor work is just something that you can carry out. It all depends on the complexity, and that will be then determined via the building control officer. That will then basically be then determine if you have to submit building plans or not for that. So conditions of that authorization is then that of the building control officer. Now, what is minor work, building work? It's been defined in the national building regulations as the following: a poultry house not exceeding 10 square meters in area. So if it's 12 square meters, it's not minor works anymore. But remember, you still have to get approval first. So you have to do an application, and the application must be approved. And if that application needs then to be a full submission of a full set of building plans submitted to the local authority, then it needs to be like that. An aviary not exceeding 20 square meters, a solid fuel store not exceeding 10 square meters and 2 meters in height, a tool shed not exceeding 10 square meters, a child's playhouse not exceeding 5 square meters. So if you've got a doll's house and that the thing is 15 square meters, an old Wendy house, for instance, you need plans. A cycle shed not exceeding 5 square meters, a greenhouse not exceeding 15 square meters, an open-sided car caravan or boat shelter or a carport where such shelter or carport does not exceed 40 square meters in area. But don't get now excited and say, oh, I can do a carport and I only have to get permission from the local authority to do so, because there's something else that's coming up later on. An open, okay, that I've already done. Any freestanding wall constructed of masonry, concrete, steel, aluminium, or timber, or any wire fence where such wall or fence does not exceed 1.8 meter in height at any point above ground level and does not retain soil. Any pergola, a private swimming pool, a change room not exceeding 10 square meters in area at a private swimming pool. Now, in many, you will find that some local authorities will require full plans for private swimming pools. Why? There might be swell clay in the area. There might be dolomite area in the area. So it's a precautionary reason why they actually need that. That is why it depends. That is then the building control officer that have to decide whatever you need to do so. And the replacement of a roof or part thereof with the same or similar material. If you're going to take your corrugated iron roof off and you're going to replace it with a tiled roof, it's a new plan because you change and alter the structural requirements of that building. Sorry, I've duplicated a few slides here. Then the replacement of a roof, okay, that I've done. The conversion of a door into a window or a window into a door without increasing the width of the opening. Again, here, the building control officer might now actually found that it's affecting the envelope of the building in terms of XA and might actually require you to submit full plans. So again, it is not because it's listed here that you do not have to submit building plans. You have to apply first, and then based on the outcome of that application, you will know what to do. The making of an opening in a wall which does not affect the structural safety of the building concerned, and the partitioning or the enlarging of any room by the erection or the demolition of an internal wall if such erection or demolition does not affect the structural safety of the building concerned. The erection of any solar water heater not exceeding 6 square meters in area, we all do those things these days, or 12 square meters when erected other than on a roof, and the erection of any other building where the nature of the erection is such that in the opinion of the building control officer, it is not necessary for the applicant to submit with his application plans prepared in full conformity with these regulations. You might just have to do a site plan or a sketch indicating what you are going to do, and that might be okay if the building control officer decides so. Then about temporary buildings. Now, in this case, the owner of the building, when they apply for temporary buildings, must declare the building to be a temporary building, obviously provide reasons why they say so. And in this declaration and in this application, then for the erection of a temporary building, they must indicate the following: the intended use and the life of the building. Normally that will be 6 months maximum. The area in which it is to be erected and the availability of suitable materials from which it may be constructed. Just going back to the minor works buildings, remember that minor works have to comply with the national building or with the standards requirements. So that's why I look at an open carport carport now, for instance. If that is out of steel, for instance, steel design is not covered by the national building regulations, and there's no deemed to satisfy in the 10-400s. That means that that steel structure needs to be the subject of rational design, and in many cases, then it needs full submission of building plans for that matter. Then we come to stalls or similar buildings to be erected as part of an exhibition. That can also be deemed as a temporary building. So if you're going to have a show or a church bazaar or something, and you're going to put up stalls in the wall, remember that a plan needs to be submitted showing then aisles, passageways, escape routes, and firefighting equipment for the duration of that use. The same with experimental demonstration, testing, or assessment purposes. Application needs to be made to the local authority, and such permissions then shall be granted based on the requirements of the local authority. You might still have to submit full building plans. Okay, I just want to highlight there. The moment it's going to affect the structural strength or stability of the original building, it will render any escape route from the original building less effective. That's no stalls and stuff or experimental buildings, and will affect the health of persons using the original building. You're going to affect the rights contained in the Constitution, and therefore local authorities might require us to submit full building plans for such. Now, where in terms of these regulations an obligation is imposed or may be imposed on the owner of the building or land to do or to refrain from doing any particular act or thing, and such owner and some other person have lawfully agreed in writing that such other person shall accept such obligation on behalf of the owner has, where required by the local authority, furnished the local authority with written proof of the fact contemplated in paragraph A and with the name and address of such other person. Any reference in any such regulation to such owner shall then also be construed as a reference to such a person, provided that such owner shall not be relieved of his obligation where the other person then does not adhere to the agreement. So if you are going to be, let's say you're the owner of a mall and you're going to have tenants in there, and there's an agreement and that the tenant will then basically comply, then there's a lawful agreement that will accept the same obligations. It is still the owner of the building that is going to take the ultimate responsibility if something goes wrong. Next, we come to the plans and particulars to be submitted. What needs to be submitted to a local authority for plan approval? A site plan, and we're going to look at the conditions or the requirements of a site plan. Layout drawings, that's plans, sections, elevations. A fire installation drawing, if there's any fire hose reel or fire hydrant or sprinkler system. A drainage installation drawing, with other words, if there's any drain on the side that connects to a sewer or to a septic tank, etc. Particulars of any existing building which is to be demolished and details of the method of the demolition to be used. So you can't just say there to be demolished. You have to basically detail how it's going to be demolished. Then plans as required by the local authority when it comes to general structural arrangements. If those general arrangements are not required by any of the other deemed to satisfy requirements of the standards. General arrangement of your artificial ventilation system. A fire protection plan. Now, a fire protection plan differs from a fire installation drawing. Fire protection plan indicates firewalls or fire separation walls. It indicates escape routes, signage, emergency lighting requirements, and those type of things. If you are going to use a product or a system approved by Agramo South Africa, the Agramo certificate, and then particulars required in terms of any other applicable legislation, bylaws, or any part of 10.400. That is what is needed. But apart from that, what forms part of your application to a local authority is also the declaration that the designer makes in terms of Form 1 on how he or she is going to apply, comply with the applicable building regulations. So without that, a building plan submission is not complete. Now, I've heard the excuse sometimes, oh, my local authority do not require these forms. As you've seen here, the regulation doesn't say that the local authority may require that. The regulations say the owner have to submit. So it's not up to the local authority here to decide what is needed and what is not needed. We are under a legal obligation to submit those to the local authority. And I've just got a few things here. Here is an example of a layout plan. Detailing again. Show what is required. Okay, this is now a simple house plan. It's actually two next to each other. But you see there the sewer layouts, the sections are not in there as yet. The annotations, etc., that are needed. And the more complicated it becomes, the more plans you might have to submit and actually start doing layout plans for drainage, layout plans for lighting, layout plans for this, layout plans for that. And look at your scale. We'll come to a thing here that say, yes, you can submit to a scale 1:100, but sometimes with all the information that we have to submit these days, 1:100 plan might not be sufficient to show all the details. Elevations with annotations to it. You see some tables, hot water requirements, and some detailing. This is part of layout plan still. window and door schedules, compliance with XA, for instance, the schedules, uh, lighting and ventilation, which we will deal with in the third session, oh no, sorry, in the fourth session, the last one. Sections, make sure that your section is of such a scale that you can show detail. Remember, you have to communicate to the contractor and to the local authority. I've seen a lot of 1:100 sections with not even the basic information in there, where details are wrong, etc. So a section is basically a detail. If you cut that building into two parts, how does it look? What do you see? How is everything there? And also then the detailing there. Foundation details. Remember, in many cases, we can satisfy the foundations without the use of an engineer. A site plan. Note the position of existing buildings on the site plus the position of buildings on neighboring sites. Now, although the national building regulations do not require us to do a water layout plan, in this particular one, I've done one, but that is for a specific purpose. And it's also to show the position of hot water in terms of part XA. I'll talk a little bit in one of the others when we come to part W or one of the other standards later on regarding the requirements of water reticulation. It is not required in terms of the national building regulations to submit such details to the local authority. I've combined in this case, and that's quite easy to do so if it's a small building, fire protection and services in one drawing. Showing then the red color there is just the way that I do it. The fire, what I call it, fire separating walls, the escape routes, the signage, etc., and some detailing, as well as a schematic layout of the fire services pipes as required by part W. Okay, let's go to the text further. Remember that you can apply from exemption from the building control officer not to comply with certain aspects of the national building regulations, where it does not affect the, or to council, not to the local authority, not to the building control officer, to the local authority, where it does not affect the structural system of the building. And where it affects the structural system of the building, you can actually apply to the NRCS not to comply with certain aspects of the national building regulations. A lot of us do building plans up to stage 4.1. So your agreement with the client is that you're going to render services up to municipal submission. However, in terms of the National Building Regulations and Standards Act, your duties in terms of that legislation ends with the issue of the certificate of occupancy. And it's not the same as doing stage 4, 5, and 6. Stage 4, 5, and 6 is basically contract management, where we as architectural professionals are normally the principal agent, and we manage the building contract on behalf of the owner. However, in terms of the National Building Regulations and Standards Act, our duties as a designer does not end with the submission and the approval of the building plan. There are certain aspects that our services are still required by the owner, especially if they want to change certain things before before it's erected on site, that we have then to come in as our name is on that Form 1, and that we are the only person then that can go and do such changes or alter the declaration that we have done. Regulation A3 require you, especially if there's a gray area in interpretation of how to comply with the building regulations, to go here, and that's normally here in stage 3, to the local authority, make an appointment with fire, with building control, with traffic, whoever it is, just to sort out a problem. And you will see that in 10.400 Part A, you are required now to get that in, well, the regulation required to get that answer in writing, and that you then attach that answer that you've got after you've consulted with preliminary plans to the local authority, and they're giving you a way that they're going to look at that. That needs to be attached to the building plans that you submit, so that whoever then check the building plans for compliance don't come up with another requirement then, and that the original arrangement then will stay in place. Remember that the local authority at any time can require additional documents, information, other than the minimums that are required in Regulation A2. Okay. And I'm not going to go in detail here, but they can ask you to furnish structural arrangement drawings other than those that are required by the different structural parts, Part H, J, K, L, M, and N. Additional detailing to be submitted to them so that they can make a determination if the building is going to be safe or not. Artificial ventilation systems, calculations that you have done to come to certain conclusions, fire resistance ratings for different materials. There's quite a lot of them if you go through that list in Regulation A4. Or especially where a design has not been carried out in accordance with any standard or document, with other words, where it's basically the result of a rational assessment, like straw bale walls. They can actually ask for additional information. How do you know that this wall will withstand all these impact loads and wind loads and stuff like that? Those details, those calculations then needs to be furnished to the local authority. When it comes to structural concrete, they can actually ask for reinforcement drawings, the grades of the concrete that is going to be used, the type of reinforcement of pre-stressing concrete or tendons, the amount of concrete cover, okay, which is quite often left out, the details of joints between members, the details of anchorage of pre-stressing steel. Now, that is normally what the engineers will do. There's also the misconception that we do not need to submit the engineering drawings for plan approval purposes, only when the local authority do not require that to be submitted as part of the plan approval for plan approval process. But the regulations do actually require that all other structural details, which is not required upfront, needs to be submitted to the local authority at least 3 days before the work is actually executed on site, and then it will be deemed to be part of the approved set of drawings. As you can see there, the different structural steelwork, structural timber, roof construction, etc. So I'm just going to skip through that. I have provided SACAP with the PDF. I'm not sure if the PDF is going to be made available to all of you. I'm just going to request them to do so that you've got the presentation and you can go back. But you can also go to different websites and just go and look at the regulation itself, because it's actually part of the regulation. Okay, now we come to A5, and A5 deals with application forms and material scales and sizes of plans. First of all, when you apply, that application form must be dated and signed in black ink by the owner. Next week, we will talk about power of attorney. Can you do it as the architectural professional on behalf of the owner if you've got power of attorney? Any application shall also be accompanied by at least one set of plans, drawings, and diagrams. It must be clear and legible. Now, these days, it's much clearer and legible than it was in the past, because remember, these regulations were done still when we draw in pen on sepia or film. Today, it's all computer, and we can make PDFs, and we can print on plotters. That gives us basically photo quality drawings. It must contain the name of the owner of the site concerned. That is now the application form, and it must be dated and signed in black ink by the owner, and every subsequent alteration shall be likewise dated and signed. So if you change on a plan, the owner must sign. We found that runners do it these days, and the architectural professional only do so, but remember, it's the owner that submits. So the owner must also actually certify that that is done, and that it actually that you've got his permission to change those. I've heard about issues where professionals have changed plans that were submitted so that they can get approval, and then the owners were not happy with the requirements or whatever they've done. With other words, there was basically a breach of contract, and then big issues afterwards. The drawings must basically be the ISO A sizes, and the following scales needs to be used. Site plans, depending on how big the site is, 1:1000, 1:500, 1:250. For dwellings, normally it's 1:500 or 1:150, depending on the size. You can actually go bigger to 1:200 or 1:100. Plumbing installation drawings, as you can see there, layout drawings. Layout drawings now includes elevations and sections. General structural arrangement drawings and structural details. General structural arrangements will also refer then to sections through buildings, and not just under the layout drawings, and then fire protection plans. So that the basic rule here is the scale that you use must be so that you can show the detail so that it's readable by anybody else who's going to look at that. The coloring of at least one copy of the plans that you submit. The colors that needs to be done there. New masonry will be red, new concrete green, new iron or steel blue, new wood is yellow, new glass black, and existing materials all gray, and then all new other new materials clearly indicated in colors, apart from the colors that we mentioned already. And I believe that some sort of reference then made to what those colors mean. On site plans, proposed work must be colored in red, existing work not colored, and if you want the work that is going to be demolished, in black dotted lines. On your drainage installation, drains and soil pipes, brown. And remember, you do not get a sewer on a site, you get a drain. Sewer is belonging to the local authority. Waste pipes is green, soil soil and combined vents red, waste vents blue. So basically what it tells you is that drainage installation drawings are not just plans, but it might be also sections and elevations. Escape route on your fire protection plan, which is now not required for residential buildings, as you will see later on in part T, but that must be in green, indicating the travel area. And then one of the biggest issues that we've got, or that local authorities got, is that when we print out our plans these days, the lettering is so small that nobody can actually read it. So capital letters must be at least, after it's been printed, 2.5 millimeter in height. Nothing less than that. The requirements for site plans. And here again, the incompleteness of site plans, when I look at some, or sometimes I'm being asked to look at drawings submitted to local authorities, and when you look at what is being submitted, the lack of information, the dimensions of the site on which the building is to be erected, the boundaries of the site, the dimension position of any building line, and the position and the width of any servitude or right of way to which such a site is subject. The registered number or any other designation then of such a site, the direction of true north. That's also a thing that is not always been shown on plans. And if it's required by the local authority, the natural ground contours at suitable vertical intervals or spot levels at each corner then of such a site. And when it comes to spot levels these days, you can actually go and do it with an app on your phone. So it is not something that is quite difficult. Contours, go and Google it. You can actually, from Google Earth, create your own contours with freely available programs these days, and it's quite easy to do. The name of the street upon which the site abuts, the location of municipal service and any connection point thereto, any drain, stormwater drain or surface channel existing upon such a site, the location of the proposed building, the existing building, if there is any existing building, and any building that needs to be demolished, the existing and intended point of access from any public street. Okay, I'll talk a little bit later on the public safety regarding certain other requirements there. And then the location of any street tree, street furniture, apparatus, or equipment relative to such access. I've seen plans where entrances were indicated to the site, and then right in the center of that is a electrical pole or kiosk or something like that, which then at great cost had to be relocated because everything already was accepted and approved. And in many cases, it only get picked up after construction on the site already had begun. A7 is your layout drawing. Consists of as many plans, sections, elevations, and details. So, with other words, as many as what you can do to communicate what you want to show to the local authority. Must show foundations, must show floors, walls, fixed and openable windows, fan lights, louvers and other ventilating devices, artificial ventilation systems, which includes then extractor fans, including also tower and plant rooms, doors, stairs, roofs, and chimneys. Sanitary fixtures, structural members required in terms of regulation A41A, the intended use and horizontal and vertical dimensions of room and other spaces. So if it's a garage, you say the garage, then it can only be used as a garage because I haven't put it in here, but A25 makes it an offense to actually to use that room then for anything else. And all details relating to the facilities provided for persons with disabilities. With other words, first of all, if it needs to be an accessible building, the building must be first of all accessible, and then you have to indicate the facilities. I've seen and I've firsthand noticed, I've done in the past, for instance, a rational assessment on an existing building where the local authority insisted on a rational assessment because the dimensions of the accessible toilet, and remember, it's not a disabled toilet. A disabled toilet cannot be used because it's disabled, so it's an accessible toilet. We're not according to the dimensions given in Part S, and they didn't want to approve the building plan due to that. But when I got to the site, I actually found out that you can't actually get into the building in a wheelchair because the access to the building was all steps. So we need sometimes not just to go and check because that's on a checklist, but we need to see everything in with holistically. With other words, if you have to provide accessible facilities, make sure that it can be reached. With other words, that the building is actually accessible then as well. And for that reason, go and look at passage widths, door widths, etc. There is a new Part S to be published in the very near future as a draft, where much more of these details have been incorporated. Please note that H4s do not have to comply with or are excluded from complying with Part S at the moment, but H3s, with other words, 2 or more residential dwellings units on the same site, do have to comply. Fixed seating, the layout of the rows, etc., and then damp-proofing material. Not just DPC. What is the size of that DPC? What type of material is that DPC? Then the location, the levels, and the size of any paved areas adjacent to the building. If so required by the local authority, contours of the site, the levels of the adjoining verge of the roadway, that is to make sure that water doesn't stream into the property, together with a section along the length of any vehicle driveway, which shall show the relative levels and gradients. That is a Part D requirement, and fortunately for most of us, H4s will then be excluded there. We're required also by the local authority the levels of the floors relative to one another and to the existing ground structure, the proposed finished ground surface, and the surface of any public place or public street at the boundary of the site, and all street levels as per Regulation 812. Stormwater drainage on the site where the drainage is required by the local authority. Please read it in context with Regulation R. Come to that later on, but Regulation R, sub-regulation 2, do not require stormwater drainage for sites where a single dwelling is going to be erected. Details of any special provisions required in terms of these regulations then for disabled persons. That includes then passage widths, etc., and where provided the location, type, and capacity of water heating installations. The location, the type, and the capacity. Where is it? What type is it? How big is the storage water heater? How big is the heating element? With others, the capacity. There are requirements for that. It's not just, it's a 200-liter geyser connected to solar. What is the solar absorptance area then of the solar collectors, for instance? And where provided, details of fenestration, window and door schedules, insulation shown on sections, etc., to comply then with Regulation XA. Plumbing requirements in terms of Regulation A8. Now, the fact that the Regulation 821C require drainage installations and 821D fire installations will not basically say that's all that we have to do. So it cannot be construed as that's the only that we need to do. So we might have to comply with a little bit more. And if you've got similar things on every floor, then one floor layout, as they say here, will be sufficient to show such drainage layouts, etc. And remember, that is also plan sections and elevations to show how it is going to work. Especially where it comes to, so I just want to take something out of the way, the fire installation that we need to do in terms of Part W. The location, the size of any existing or proposed communication pipe, as well as the service pipes, the material from which it is manufactured, if required, capacity of storage tanks, overflows, location of pumps, pressure for which the installation has been designed. Location of overflow is quite important, especially in swelling clay and dolomitic areas, because you don't want overflow water to come and pond near the foundations. Then also the location, the size, and the gradient, with other words, a section through a drain, the connection point to such a drain, the location of any point of access to the interior of such a drain, with other words, rotting eyes, manholes, inspection chambers, the location of any point of sorry, I've done that. The location of any trapped gully. Remember, there must be at least one gully per building. The location and details of septic tanks, conservancy tanks, private sewage treatment plant, or sewage pumps. If you're going to have a French drain, obviously, before you can actually even design a French drain, you have to do a percolation test. So the percolation test hole must be shown on the plan. The arrangement and the location of sanitary fixtures served by this drainage installation, the size of soil pipes, waste pipes, and ventilating pipes, the location of all openings in the building, such as chimneys, skylights, doors, windows, ventilation openings, and air intakes, which could permit then the entry of foul air or gas into the building from any ventilating pipe or device, the location of a well, a borehole, or a water course that's on the site, and the local authority may require the additional information, drainage calculations, the estimate of the consumption and quantity of industrial effluent, and where approval has been granted for industrial effluent, all the requirements in terms of the bylaws that needs to be shown then on the building plans. There are specific symbols that we need to use on drainage plans, drainage installation plans. Don't make up your own. They are there as listed. They are in the regulation. And if there's any doubt or anything, doubt that it might cause confusion, write it out. If it's not a dwelling house, and if required by the local authority, a fire protection plan, and then all clearly indicating the protection measures. Now, I think most of our local authorities will require that. However, it does not say that you have to have a separate plan for that. You can indicate that on your normal layout plan if it's small enough, and you can actually show all those details on there. On your fire protection plan, clearly mark the following: escape door, escape routes, etc., with the let's call it the symbols as indicated there, or the abbreviations as indicated there. And then the classification and the designation of occupancies. Now, first of all, you need to show that on the building plan. Why? Because based on that, certain requirements in terms of the regulations will then come into play, and everybody will know this is what the regulations then, or not regulations, requirements are then in terms of the standards that we must then comply with. Different requirements for different type of occupancies, especially when it comes to fire protection and a few others. So the classification on the building plan shall reflect the primary function. So if it's a school, you will say A3. You will not say, okay, there's an A1, A3, and there's a G1, and there's an A1, etc. You look at the main occupancy. If it's clearly that it's a school. But let's say you've got a building on a small holding. One part is residential, and the other parts will be associated with farming activities. Then it will be dual, and then you will have to deal with each type of building with its main or its primary function. Okay, so there you might have then to separately classify the different occupancies of the different types of buildings. Because the farming shed is not going to be an H4, it's going to be something to do with like a store, etc., to deal with farms, where the house is going to be then purely for dwelling purposes. However, if it's ancillary, it will be part of the main thing. So let's look at a motor dealership. What is the main purpose of a motor dealership? It's to sell motor vehicles. So it's a large shop, 10 to 1. but it might have ancillary to it a service center, which might be a B2. But the main occupancy will be then F1, large shop. Specific requirements for J1 occupancies as indicated there. I'm not going to go in detail there. It's there for us to read, but when you deal with that, make sure that you deal with that on the building plans as well, and that you communicate as required then to the local authority as well to the construction team then the requirements. Here is just a list of the occupancy classes, and I believe that as an architectural professional, we should know this by heart. You do not have to go back to a table to check every time what is it. If somebody talks about an office, you have to know immediately that it's a G1. If they talk about a school, you have to know it's an A3. If they talk about a mall, that you know that it must be an F1. If they talk about a museum, you have to know that it's an C2 for that instance. It's something that we have to, if you don't know it, learn it and make sure that you know it, because it will make life much easier when it comes to submission of building plans and compliance then with the different requirements of the national building regulations. Okay. And that brings me then to the last section, which is the intent 400 part A, where I just want to highlight one or two aspects there. Sorry, that is on there. Now, I don't know how many of you have looked at the 2020 edition, I think, of Part A. There's an amendment coming out soon, but it's just an amendment, so it's not a big issue. But there is a checklist for all these things that we have to submit to a local authority already in our standards. It's not compulsory. It is there for voluntary use. But it's a checklist. There are two checklists. The one is a checklist for use by owner or the designer before submissions of plans to a local authority. And there you just tick off. Is it yes or is it not applicable? For instance, details of owner on plans. Yes. So if you tick the box there, you know you've done it. You know that it's done. Details of professional, architectural professional, engineering professional on plan. Yes. Municipal submission forms completed and signed? Yes. Copy of title deed attached, if required? Yes. Zoning certificate, if required? Yes. Copy of approved SG diagram? Yes. Building line relaxation approval letter, if that was applicable? Yes. Schedule of area, that is FAR, coverage, height, etc., shown on the drawings. Heritage approval for changes, demolition required? Yes or not applicable? And if it's yes, obviously attach it. SANS 10-400 Form 1, declaration completed and signed by the parties. Form 2, completed and signed by the parties if required. Proof of registration of architectural professional, with other words, is at least the QR code of your privy seal on your building plan. Documents, plans to be submitted as per NBR regulation, and then that's the following: site plan, layout plan, elevations, sections, fire installation drawings, drainage installation drawings showing existing and proposed sewer drains and connecting drains, particular of existing buildings to be demolished, including details of demolition method, general structural arrangements, artificial ventilation, fire protection, testing, agramo certificates. List goes on. Additional documentation, documentation details as required by NBR Regulation A5. Site plans 16, 17, and all the things there. Layout drawings, 18 plumbing installation drawings, 19 correct use of symbols on fire protection plans. And that, if you just check that, I think there will be no problem with submitting a building plan to a local authority. And a similar form is available as Form F2 for local authorities. When you submit a building plan for them, just to go and check that when you submit building plans to the local authority, that they then check that you have submitted all these documentation from that they will require from their side as well. And that, ladies and gents, brings me then to the end of this first session, where we deal with issues with submission of building plans to the local authorities. Thank you from our side.
Thank you immensely for everyone's participation in the episode 1 of our series webinar on referrals. The presentation will be shared with all attendees, and also the video will be made available on our YouTube channel. The channel page is We Are SECAP. So if you go to YouTube, you search We Are SECAP, and you subscribe to our channel to access all our recordings. Our next webinar will take place next week on Wednesday, 24th of April, same time, 10 to 2. In our upcoming session, we will delve into topics from Form 1 to Form 4 of Sense 10400, competent persons, and also power of attorney. So we thank our presenter, Mr. Franz Decker, and thank you once more for your attendance. Until we meet again next week, please stay inspired and empowered. Thank you. We then adjourn our webinar. Please take time to complete our polls before leaving the webinar. Thank you.